are on the application of Majera, formerly SM Rwanda, Appellant, against Secretary of State for the Home Department, Respondent.
Mr. Majera is a national of Rwanda who came to the United Kingdom as a child and was granted indefinite leave to remain. After being convicted of serious criminal offences in 2006, he received a sentence of imprisonment for public protection, and in 2012 was made the subject of a deportation order which has never been implemented. In 2013, he was transferred to open prison conditions and worked as a volunteer at a charity shop. In March 2015, when he was released on licence, the Secretary of State decided that Mr. Majera should be detained under immigration powers pending his removal or departure from the United Kingdom. In July 2015, Mr. Majera applied to the First-tier Tribunal for bail. The tribunal decided that Mr. Majera should be released on bail, on condition that he report to his offender manager and subject also to the conditions of his licence. The Secretary of State sought a condition prohibiting Mr. Majera from continuing to perform unpaid work, but the tribunal decided not to impose such a condition. The bail order did not require Mr. Majera to appear before an immigration officer at a specified time and place, as it should have done. Later the same day, an immigration officer gave Mr. Majera a notice which imposed a restriction that he could not perform unpaid work, contrary to the tribunal's decision. The notice also imposed a curfew on Mr. Majera. The Home Secretary refused subsequent requests by Mr. Majera for the withdrawal of the prohibition on his carrying out voluntary work and for the relaxation of the curfew. Mr. Majera then applied for judicial review of those decisions, on the ground that the Home Secretary could not lawfully impose conditions which the tribunal had declined to order. In response, the Home Secretary conceded that the curfew condition was unlawful, but argued that it was lawful to impose the condition relating to unpaid work, because the bail order was legally defective and therefore void. The upper tribunal decided that the Home Secretary's decisions were unlawful and made a declaration that Mr. Majera remained on bail in accordance with the bail order. The Home Secretary then appealed successfully to the Court of Appeal, which made a declaration that the bail order was invalid and had no effect in law. Mr. Majera now appeals to the Supreme Court. His appeal raises a question of constitutional importance: whether the government, or indeed anyone else, can lawfully act in a manner which is inconsistent with an order of a judge which is defective, without first applying for and obtaining the variation or setting aside of the order. The Supreme Court unanimously allows the appeal. It's well established that a court order must be obeyed unless and until it has been set aside or varied by the court, or conceivably overruled by legislation. This rule applies to court orders whether they are valid or invalid, regular or irregular. The reason for the rule lies in the rule of law and the basic principle that court orders should not be ignored by anyone, including the government. Rather than applying this rule, the Court of Appeal decided, on the basis of case law concerned with unlawful administrative acts and decisions, that the bail order had no legal effect, and so the Home Secretary was not required to comply with it. Even in the context of administrative acts and decisions, it's an oversimplification to say that an unlawful act has no legal effect at all. There are a variety of circumstances in which an unlawful administrative act may have legal consequences. In any event, the present case is concerned not with an unlawful administrative act, but with an order of a judge, and so gives rise to different issues and is governed by different principles. In this case, even if the bail order was invalid, the Home Secretary was nevertheless obliged to comply with it unless and until it was varied or set aside. She was, of course, entitled to apply for it to be varied or set aside, but she had not done so. The allegation that the bail order was invalid was not, therefore, a relevant defence to Mr. Majera's application for judicial review. As there was no other basis on which the Court of Appeal reversed the decision of the upper tribunal, and the Home Secretary doesn't ask the Supreme Court to dismiss the appeal on any other grounds, it follows that Mr. Majera's appeal must be allowed. The result of the appeal means that the order of the upper tribunal quashing the Home Secretary's decisions and declaring that Mr. Majera remains on bail in accordance with the bail order is restored. The Court will now adjourn.